Carol Volley, and I have the pleasure of introducing Jim Karl tonight. Who is going to be speaking. And Jim is a good friend. We've known each other for a few years, and when I pulled up his last year when he spoke to us, and I was asked to introduce him, I thought, wow, I know Jim's talented, but he's a pretty high achiever too. He's got quite a resume. On his website, he keeps it pretty simple, but he's the kind of person that probably has really a 27-page CV. Anyway, Jim received his BA from Washington College, his Bachelor of Comparative Law program from Oxford University, and his Juris Doctorate from Cornell. He has a practice on Marco Island called James Karl & Associates. He provides a broad range of legal services to individual and business clients throughout Florida, the United States, and beyond. Established in 1987, the firm provides a full range of legal services representing and advising clients in the areas of civil litigation, business and corporate law, estate planning, contracts, personal injury, real estate, criminal law, and family and domestic law. And with Jim being such a leader now in the grandparent rights, we were saying today he needs to kind of change this, and we need to put that right at the front. Thanks, Jim.
I'm going to pass out just a little. The second part of I'm going to give a very brief introductory talk. And then if you could just pass and take one of these. I'm going to try to do a short workshop as the second part of my talk. I thank you very much, the board, members, leaders, all of you that make AGA such a great organization to be a part of, and for giving me this opportunity to come and talk to you periodically and sort of share some of what I've done in the past year. Last year, I think was kind of interesting because, as many of you may know, and I'm not going to presume anything, but the state of Florida has been somewhat, I won't say a leader in grandparent rights because, quite frankly, as you will see, there have been a lot of disappointments. However, they've been very vocal. They've had a lot of activities. And I think in the end, I'm certainly optimistic that Florida can be one of those states that can perhaps take the charge ultimately in creating some legal momentum with regard to grandparent rights. As it currently sits now, 34 of 50 states have some kind of grandparent rights statute. Florida is not one of them. So Florida is one of those states that really essentially has nothing for grandparents legally with regard to a petition for visitation. Now that's not completely true because there is one part of the Florida statute, the grandparent statute that was passed in 1984, that has not, since that date, been declared unconstitutional. And that's in the case where a parent has deserted the child. Other than that, pretty much there's nothing. There is a temporary custodial provision, Florida Statute 751.03, that would allow a grandparent to petition for temporary custody in cases where there's consent by the parents. You see that more than you think. Sometimes the parents say, tired of these kids, can't afford them. Grandma, grandpa, dad, take care of them, I'll let it go. And this temporary statute gives them an avenue to do that, where if they change their mind later, they can pretty much get it back. The burden is not too high to actually revoke that consent. But also, it gives the grandparent an opportunity to sue for custody in cases, temporary custody, in cases of abuse, abandonment, or neglect. That statute, that temporary custody statute sounds like it might be somewhat useful. I haven't seen much use in the practice because really those abuse, abandonment, or neglect, each one of those has a definition that essentially is to be a determination, definition and determination that's made by essentially DCF. In other words, if you as a grandparent suspect that a child has been abused, abandoned, or neglected, your duty is to report it to the hotline, essentially. And once you report it, DCF takes the charge and and does an evaluation or determination. And that determination is essentially final with regard to whether or not you can go the next step, which is to ask a judge to grant you custody on a temporary basis. So it's there in extreme cases where the facts are conforming, but it really doesn't help. So at the end of the day, I think it's fair to say that Florida doesn't have anything on its books that helps us right now. That's the bad news. Now the good news is that in March of 2013, a senator, state senator, started a bill through the House, Senate Bill 384, and it didn't, by the way, never came to a vote in the 2013 term. It's not on the 2014 agenda. However, we are patient people, right? We've learned to be patient. There was some progress made, and I think I'd like to take a few moments, and please tell me if I get too long-winded, because sometimes when we get into some of these details here, they're important and they might not be the most interesting. That's why a lot of people say the law can be a little dry. My son tells me, Daddy, those meetings are a little boring, you know. But I will tell you that it's pretty exciting for those of us that are really looking for something to happen. But I want to be clear, nothing's happened. But I think that we've got the sort of groundswell of something, and with the help, and we've had a lot of help from this organization and from others that could, you know, I encourage all of you to keep it going, and you'll see what I mean. Okay, so what Senate Bill 384 did is, number one, evaluated the situation as it stands in Florida. So let's start with this handout I just sent to you, okay? Bypass the first two pages, which, by the way, these two long, right to the boring pages, those are two prospective bills from two states that I think have done something interesting. We'll talk about it. But I want to go to this little thing right here, because I think we'll jump right to that, and let's read it. In fact, if you don't mind, I'll call it, Karen, can you read that Article 1, Section 23 of the Florida Constitution? Go ahead and read that for us, if you don't mind. I don't mean to be professor, but go ahead.
Right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into his private life, except as otherwise provided.
Okay. Now I'll make it easy. There is no otherwise provided herein that applies to us. So now I'm going to read it as to what it is. Now remember, this is the Florida Constitution, which is the highest law in our state. Now read it one more time. Every natural person has the right to be let alone and free from governmental intrusion into his private life, period. That's the Florida constitutional right to privacy, set forth in the Constitution. I don't know how many states actually have a specific right of privacy written into the Constitution. Florida is one of them. It's a minority. Okay, maybe 10, 15. It's not many. But those states that have that in their Constitution have built a wall, making it harder in those states to get a meaningful grandparent right visitation statute, because of the right of privacy for every natural person to be free from governmental intrusion. And you know, the first thing the layman on the street says is, hey, so what? I mean, come on, that's great. We want everybody to be free and have privacy. But we also want children to have access to their grandparents. How's that effective? Well, let's take a look at it. What really happens here is that the right to be left alone by governmental intrusion means when the government comes in and says to a parent, must, here's a statute that allows you, that allows us to say to you that you must give access to your child to that child's grandparents. That is a governmental intrusion. And this says that we're to be free from that. Now, does that mean in every situation? Of course not. I mean, there's intrusion. Some of us like to drive over 70 miles an hour, right, on the highway. Can't do that, right? Why? Well, there's this compelling state interest to protect the safety of other cars from accidents and so forth. Same thing applies here. There is, but there's the way in which the lawyers and judges look at this is that there has to be, when you have language like this in your Constitution, a compelling state interest. Compelling state interest in granting these rights of visitation. And if you establish there's a compelling state interest, then you have to define your law with what we call strict scrutiny. So that means it has to be the least expansive law. You have to have the smallest law you can. This is what the Constitution's require. In other words, they will grant the right to petition for visitation, but it's got to be very narrow and completely directly related to the compelling state interest. Okay, now let's get to down to the facts and see what this looks like. So, state bill, what the senators did, the state senators, in Bill 384, is they said, okay, we've got this language in the Constitution. We also have several cases that the Florida Supreme Court has decided, based upon the old 1984 statute, that found problems. We'll strike out the one that says that where parents have divorced, grandparents can petition for visitation. Now, that's not enough. Compelling state interest. They struck down the one that said where the child was born out of wedlock, the parents have the right, the grandparents have the right to petition for visitation. We'll strike that out because that's not a compelling enough state interest and it's too broad. We'll strike out all other aspects and leaving just the one that I mentioned before where there's been a desertion. And I'm going to just read to you what basically the leading case in Florida, one of the leading cases, 1996 case of Bagel versus Bagel says, the right of privacy is a fundamental right. These are the judges in the majority of the city, which we believe demands the compelling state interest standard. Okay, now we know that. This test shifts the burden of proof to the state to justify an intrusion upon privacy. So if the state's going to have a grandparent visitation statute, they have got to prove that it's constitutional, not the other way around. The burden can be met by demonstrating that the challenged regulation serves a compelling state interest and accomplishes its goal through the use of the least restrictive means. So that's the standard I just defined to you. And it is as high as it gets. Okay, it's just, that's it. So and that's not something, we can't change that. Okay, what we can do is we can draft a law that we think will withstand that scrutiny. So you can imagine, we've already got the, because of this part here, we've got the wall. Now we've put some spikes and what do they call that wire up there, that razor wire on top of it. So I don't mean to be, I'm here to tell you the truth. I mean, this is what we're up against. Okay, so now, what did the Senate bill do? How did they attack this? Even though it was not voted on, so we don't know if it was turned down or if they would have had the votes. We did a little analysis. We checked with someone. We've been in contact, and it appears as though it wasn't going to have an easy sailing through the Senate. But on the other hand, then the question was, so you get, let's say we can get a statute like the one that's being could be proposed in say 2015, get it through. Then it's got to also sustain a challenge by the court, and that's what Susan has been talking about in terms of, and again, I like to try to not speak so much lawyerly as a layperson. A lot of people say, okay, great, we can pass a statute, but it's just going to be challenged and it's going to get struck down. Well, I will say one thing for the senators. They have painstakingly attempted to draft this statute, maybe too much, to the point where it has good chance of sustaining constitutional review by the Florida Supreme Court or the appellate courts. And by the way, just so you know, what happens is, if we do get a law passed, then it will give you an initial right to go in, just like you could on the dependency case, okay? Where you've got DCF involvement, they determine that there's been an abuse. You know, you have the right to petition that. There for custody, for temporary custody. Now you can petition initially for visitation. Can't do that now, unless if there's been an abandonment. So, a desertion. But, so it gives you that right to do that, if we can get this law passed. So that's a big thing. But now here's how the statute works. Here's what basically, and I think whatever we're going to get, you know, up the line, this is undergone a lot of analysis, so it'll probably be somewhat similar to this. So here's how the statute works. The first thing it says is that there's going to be you get to file, so let's say you're not seeing your grandchild. You get to go to a lawyer, files a petition, and it goes to what they call a prima facie hearing, to see if you've got, it's not a trial, it's just to see if you've got the facts that get you by the requirements of the statute, which are an attempt to get by the constitutional scrutiny and privacy. At that prima facie hearing, you're going to have to show in that statute that there has been a harm to the child. It means a physical, mental, sexual abuse, injury, or harm that caused or is likely to cause the child's physical, mental, or emotional health to be significantly impaired. They go on to say the kinds of things that have to do. And it says you can look at the age of the child, the prior history, et cetera, et cetera. So it's not a given. I mean, this statute, and I've expressed my dissatisfaction with this statute to a certain extent, because one day you wake up on this side and you say, you know, boy, they could do more. But then on the other hand, you got to remember, if they go too far, then you're going to have something that's going to get struck down just like the old one did. Okay, so they petition. You have the presumption, okay, the parent has the presumption that their decision to keep the child away from you is correct. You've got to rebut that presumption. So you've got the burden of proof. So if the judge sits there and he goes, I heard from the grandparents, I heard from the parents, I'm not really sure. They both make a lot of sense. You lose, you don't get past the prima facie hearing, and you have to pay your child's attorney's fees. So there's penalties here, you know, you better be right. That's the statute that might get through Florida. So, you know, okay, I mean, it's just the reality. Okay, but if you get by that, then the court can appoint a guardian for the child, guardian ad litem, which would probably be a good thing, because that really, you know, and I hear a lot about, and again, you got to remember, lawyers, they approach it differently because we have to try to adjudicate cases. So the best way to adjudicate cases adequately is make sure we don't have too many of them, right? A lot of this is about that, right? Because if you let the floodgates open, we'll never be able to adjudicate anything, because we won't look at the foreclosures. I mean, how long it took us to get a handle on that. So that's part of the practical problem. So we approach it, and it almost seems like we approach it unemotionally. You're sitting there saying, this guy doesn't have a heart. These judges don't have hearts. But there's a reason. I mean, I'm not saying it's great, but I mean, that's part of what we're talking about here. So now you get maybe appoint a guardian if the court sees it need be. And then they send you to mediation. That's what the statute does, sends you to mediation. You have a question?
What's the age range you're talking about? When does childhood end in Florida?
18.
18.
So now you get to the point where they appoint a guardian or they go to mediation. If mediation fails, then after conducting a hearing, then the court can, if visitation has been denied by the parents, and if the visitation will not materially harm the parent-child relationship, that's written in the statute, the court then can award the grandparent, this is the golden egg, the visitation, and force the parent to say, you've got to make this child available to the grandparent. So that's where Florida is, maybe going. And I think this statute will come, I think something like this will be brought up again. I don't think in 2014, but I do think in 2015, a good shot at getting this back up in front. But that's the way it's gonna be. It's not the greatest thing it could be better, but a lot of thought has gone through it, and there are a lot of other provisions here that guide us through this process so the judge can make a decision. And the whole point here is we want to be able to get into the court, have what we call standing. Get you guys to have standing. Because once you have standing, you get in front of a judge, and the judge then can make a decision. But you've got to get past that. And a lot of commentators have sort of followed up this by saying judges ironically, we have commentators, I'll read you one right here, it's very interesting, that the judges get too emotional. So we can't really let them have too much here because they're going to get too emotional. They're going to start doing things that we don't really want them to do. And it says here, there's a Florida Law Review article where they said that it is clear that the Florida Supreme Court is correct in deciding that absent some showing of harm, a court cannot override a fit parent's decision. Absent a grandparent proving harm to the child, visitation is going to be denied. So it's a check and balance, essentially, not just because of the privacy concern and getting past the constitutional problems, but it's also because we don't want courts to become forums for battles between grandparents and parents where the court's going to decide what the court thinks is right, because that decision, unless there is an extreme case, which all of our cases I submit to you probably are, that case is to be decided by the parent, because the parent has the right to conduct their lives free from governmental intrusion. Okay, so that brings it back full circle. So that's the struggle that's going on with the law. But once, we'll get through that. Now, you asked, 34 states have statutes. Well, most people and most commentators, a lot of the statutes haven't been tested yet. But I will submit that, for example, Alaska has a statute that says that a grandparent may ask a court for an order granting them either custody or visitation. And if you go, you can actually pull up a website, and there's a form to fill out. They tell you to get a lawyer, but there's a form you can fill out. And you go in there, and here's what it is, though. It says the parent is unfit, or the child's welfare requires that the non-parent have custody. Those are extremely high burdens. So you start looking at it, you say, well, there's a statute, we can work with that. Why doesn't Florida just do that? Well, that statute is either going to be declared unconstitutional, or it does nothing. I'm not sure which. I think a little both. Because if it gets too vague, then they declare it unconstitutional. Any questions? Am I going too fast? Okay. All right. So I think I wanted to kind of give that a little bit of background. I think once we have that background, I think we can maybe, perhaps, we can kind of do a little, I'd like to turn the second part of my talk here into, and then maybe we'll open up for some questions. But I'd like to sort of play the devil's advocate a little bit. Obviously, I know these challenges. I'd like to maybe open this up to some, for a moment here, to say, if somebody wants to tell me why, and let me hear why you think that, and how you think maybe we can get over some of this hurdle that I just described to you about the right of privacy and the right of a child, a parent to determine how to raise that child free from interference of the government. Really what they're talking about, because the government, remember, by giving the grandparents rights, is interfering with the child, with the parents' right to raise that child without grandparents if they choose, maybe the best way to put it. So, does anybody want to take a stab at it to start with? Anybody want to make the case? Why? Go ahead.
Children have rights too.
Yeah, that's an excellent point. And that's a point that, believe me, that's a really good way of putting it. The problem is that
They're minors.
they don't have legal rights. Right? You asked that question. 18. So until you're 18, and so I asked, we actually talked about this in our office, and one of the other lawyers says, and he says, Well, it's very simple. Children can't vote, right? That's why there's nothing. They can't vote. We don't need to give them anything. But it really is true. Until you're 18, you don't have any, you can enter into a contract, but it's voidable. So nobody's going to enter into a contract with a child because the child can void it. Just say, oh, I'm a child. The child can enforce it, but, so the child does have rights that way. That they can enforce a contract, but they can't be enforced against them. So no, that's a great way of putting it, but there must be something else, maybe, because, what about, here's the thing that I was thinking about. You've got a destruction, essentially, of the family unit that's taking place, culturally, right? You see it happen, and judges see this all the time. In fact, one of the commentators says, this is why the judges are so emotional. Last time, I remember speaking last year, we talked about judges that were constantly just saying, oh, thank goodness for the grandparents. Oh, grandparents. And there's a bad grandparent here, a bad grandparent there. I mean, never have the statistics been more played out that grandparents, by and large, are very, you've been through it all, right? And you're a very important part of the child's life. And it's, you can't, obviously, by the way, let me make a comment about the best interest of the child, because a lot of times this is really important. Everybody says, well, it's the best interest of the child to have a relationship, a loving contact, frequent contact with the grandparents. The best interest of the child actually has been found almost consistently by the courts to be the wrong standard to use when determining the rights of grandparents. When determining custody and visitation between dueling parents, it's the only thing we look at. But when the grandparent gets involved, we don't want to look at that. Why? Because now you're looking at, because of that right of privacy insertion, and there's some excellent language in some of the cases where they came through and they've actually switched that all around. It says, that when, listen to this, it says when the courts are asked to get involved in a dispute between a parent and a grandparent, that dispute in itself, the fact that it exists, means that if the court comes in and and tries to make a ruling to resolve that dispute, that's going to harm the child. Because the only way to do it is for the courts to back out and encourage the families to go to counseling and mediation. And this is a view that the courts are following. And really, the legislature are following. It says here that the better solution would be to shift the focus away from judicial intrusions upon families and instead help families resolve their disputes themselves through mediation and counseling. You see, litigation, not only is it's expensive, it's very emotional, I mean, so is this, what you guys are going through, but it tends to exacerbate everything that's there. So a lot of people think, oh, just get a court, get a judge to go boom. And that can sometimes create more problems than even existed prior to that. So that's why you see in Senate Bill 384, you see them trying, or actually requiring, the mediation, and then requiring the evaluation, and then requiring, make it a step process so we get to where we want to be, but we take baby steps. So, yeah.
When I was speaking with an alienation attorney on the east coast of Florida, and one of the experts, Dr. Boone, I think, they said that if a grandparent does win grandparent rights, which sometimes they do here on a lucky case, that in that decision that the court makes, that we should insist that there be written that there's a consequence if the parents, your children, if the parents don't comply with the decision of the court. Because sometimes when they do win their cases, our adult children don't let them, they make it impossible anyway to see them. This one is cold, this one has a cold, going to a birthday party, so whatever.
Yeah.
So that they have to put in that And we have to remember that as we're writing the statute. Jim probably didn't mention to you that he's been asked by the legislators in Florida to help write the statute for grandparents' rights in the state of Florida. So we have to include that there will be a consequence if the judge makes the decision, if the court makes a decision, and the parents don't
Yeah.
comply.
And enforcement's always an issue. Enforcement of court order. And the way you enforce a court order is, like Susan said, you have language in there that have consequences, such as, penalty provisions. I mean, again, you gotta be careful, because it's not like a contract where if somebody doesn't do something, it's a late charge of $150 a day. I mean, that doesn't necessarily work, because that might just be, harming the child. But the consequence, quite frankly, is a court issues an order. If the order is not followed, then the consequence is for a contempt. You go back to the court, and you ask the judge to hold them in contempt. So the first time the judge says, okay, this is what it says, I agree, and you have violated it, and I'm holding you in contempt, and I'm allowing you to purge the contempt by complying. It's kind of like, we'll give you another shot, give you another chance. And by the time you get 2 of those, or 3 of them, and that's why I say it's a process, at that point, the judge starts getting really mad, and will take actions even beyond what you write. But certainly, we'll look into the document and see if there's some consequences. But then they might start limiting. Maybe, in the crazy extreme case, you might see some increase in the visitation initially, and maybe some reduction in the visitation. Because now there really is no such thing as custody. We realize that when you talk about custody of a child, it's like a suitcase or a possession, bank account. So we don't do that anymore. We talk about visitation. We talk about joint custody with visitation, and that would spill over. There's not a lot of law on the grandparents, because we don't have a good statute. We haven't for a while, but that would also spill over. So you might see them increasing the amount of visitation that a grandparent would have, and decreasing maybe some of the time sharing, what we call it, time sharing that the parent may have in that situation. Yes.
You're speaking of Florida and Florida rules, of course.
Yeah.
But is there any state that has success in establishing something that really works?
Yeah, that's a good question, and the answer is emphatically yes. And there have been states that have been much more successful, ultimately, than Florida. And this is how, again, I hesitate a little because I don't want to get this to be like a law class, but the United States Constitution has also a written in, just like Florida, right of privacy. And when the court, in the case of Troxel versus Granville, this was a year 2000 case, where the United States Supreme Court struck down a law of the state of Washington, which it found to be, and I'll read you the language here, breathtakingly broad within the context of a best interest determination. In other words, the state of Washington had passed a law that said that grandparents can petition for time sharing, visitation with their grandchildren, and all they had to show is that it was in the best interest of the child to have this visitation. And I think you guys need to sit for a minute and think that through, because you've got to know your adversary, right? You got to know what you're up against. What's wrong with that? You might ask yourself as a person walking down the street. If it's in the best interest of the child to have time with their grandparents, why shouldn't a court order it? And that's what the state of Washington legislature did. And the United States Supreme Court said that it was breathtakingly broad because it was just a best interest determination, and it said that no consideration had been given to the decision of the parent, and the parent's fitness to make the decisions had not been questioned, and no weight had been given to the fact that the mother had agreed to some visitation. And it basically concluded that because the Washington statute violated the Due Process Clause, because the Due Process Clause of the United States Constitution does not allow a state or permit a state to infringe on the fundamental right of the parents to make child-rearing decisions simply because a state judge believes that a better decision might be made. I mentioned that before. Troxel versus Granville makes it clear. You can't take and substitute the decision of the parent with the decision of the judge. It violates privacy. So you gotta have more guidance than that. So other states have looked at that, and by the way, there's some other language in that very famous United States Supreme Court decision that says, but we're going to allow the states to kind of do their own thing, as long as they don't violate what we just said here. And so the states from that date have gone along, and they've come up with a number of provisions. And let's go back, take a look at your handout. Let's just look at two. There's one here, I've given you two. The first one is the state of Alabama. And it says here, and I'll just take a second just to read through it, and it says that any parent, we're not going to read the whole thing, but I'm going to read the key points, may file, is everybody with me? I'll wait for a second. It's the first page of your handout. Any parent may file an original action. By the way, this is important. An original action is that standing I told you about. You have the standing, you have the right to bring a lawsuit, right? That's important. I can't just sue the chaplain here. I have to have standing. I have to have something that the law protects. Same thing here. That statute's granting you grandparent standing. You don't have that in Florida, really, any usually. You may file an original action for visitation rights to a minor child if it's in the best interest of the minor child. And we know that's not enough, because Granville. But it goes on to say, and that's a very important word right there, and one or more of the following conditions exists. One of the parents has died. We're okay with that, right? That's okay. It's not enough. Well, we know that because the Florida statute had that in there. It's the 84 statute. 2, when the marriage of the parents of the child has been dissolved. 3, when a parent of the child has abandoned the minor. 4, when the child was born out of wedlock. 5, when the child is living with both biological parents who are still married, whether or not there's a broken relationship between them, and the grandparent and either or both parents have used their parental authority to prohibit a relationship between the child and the grandparent. Now that's probably where many of our cases fall, is under some paragraph 4. And you only need one, so that would be enough in Alabama. Now, has that statute been tested by the courts yet? No. If it was in Florida, that statute I submit to you would be stricken. That provision, part of the statute, would be stricken because it's too broad. And it infringes upon the state right of privacy in the Florida Constitution. So Florida's not going to get off so easy. But other states have, and they've got it there, so they can do it. And then it goes on to talk about the remedies. So yes, there have been states that have succeeded, and there have been states where things have, in fact, there's a famous case, and we talked about this case last year a little bit, where in Virginia, the mother was killed in a car accident. The father remarried, and the new wife did not like the father's parents. So the new wife blocked the contact between the parents of the father and the grandchildren. And the father, for whatever his reasons are, didn't do anything about it. So the grandparents were from Florida, by the way, I think. I'm not sure if the grandparents, strike that, they might not have. But anyway, the grandparents went to Virginia, filed an action under the Virginia statute that allowed them to do it, and got an order granting them visitation. The father, the father of the kids and his new wife moved with the kids to Florida, where at the time the grandparents were living. So they said, oh, this is wonderful. And no sooner they got down there, the new wife says, no, I'm not letting you see the grandparents anymore. The grandparents said, no problem. I got this friggin' order. I got this order from Virginia. marched right into the Florida courts and said, please, here's the order from Virginia, let's get an order from Florida, let's get the police out there, let's require them to get the state, go on, let's all of them contested. And guess what the Florida courts did? We don't like the Virginia statute. It's unconstitutional, so we're not going to enforce the order that was pursuing the statute that we think is unconstitutional. And they denied the grandparents their rights. And they said, I'm sorry, I wish I didn't have to do this. So, there's a, if anything, to me, what that says, things like that kind of an anomalous decision, means that maybe the Supreme Court needs to perhaps act again and standardize this. So that's one sort of direction we can go in. Or at least get Florida to get something on their books, because right now we're somewhat of a laughing stock, really. In that we're sitting here, we've got one of the largest grandparent populations in the country, and yet we've got virtually nothing on our books to protect grandparents' rights to see their children and grandchildren. Yeah, go ahead, Sue.
Yeah.
The Supreme Court decision in Charlottesville versus Granville, though, Jim, was a split decision. It was pretty close. I mean, it was not unanimous, right? I mean, it
That's
makes
right.
you wonder if
It was very close, and also this past, a year ago, the House of Representatives passed the appeal. AGA in Washington is part of that. And it's still waiting in
Oh,
committee
you're talking
and
about in the
Senate.
state of Washington.
In the state of
Right,
Washington.
That's correct,
If-
that's correct.
if they-
We filed an amicus brief in that.
That was
Yeah.
a separate one,
Yeah.
but Troxel versus Granville is being appealed. And AGA, our group there, is actively a part of that, Bobby Rudolph.
Oh, okay, yeah. So there's a lot of, that's
And
right.
that, it passed, that statute, that bill passed in the House of Representatives, but it's still in committee in the Senate. And it's a political decision now. One of the political parties are saying we're in favor, one's against it.
Yeah, so what, they're doing the same thing that Florida's doing. Except they're trying to get they don't have the state constitution on their back. They've got the federal constitution on their back.
But if
and
they
they're
can
trying-
change it there, if they can overturn Troxel versus Granville, that should have a
But that's-
trickle down effect for us.
Yeah, no, it doesn't work like that, not exactly, okay? So they're not overturning, you can't overturn the Supreme Court decision. You can pass a statute that works its way around the decision, so the decision is no longer applicable. And that's really what we're trying to do in Florida, the same thing. We're trying to pass a law that said that where our line of cases,
So
okay?
then what's the pathway? Should the pathway be through the 50 states, or should the pathway be aggressive toward Washington DC? What's the pathway?
Yeah, well, you have no choice but to go through 50 states right now. And now, what could happen, now you remember, you're right, the decision, the U.S. Supreme Court decision in Troxel versus Granville was a split decision, but it's still, the law is the law of the majority decision. That's the law that it creates. And the split, decision sort of clarifies some gray areas that are around that. But the concept that the statute has to be specific enough, it has to be specific, and it has to give weight to the decision of the parents. That's why you see in the Florida proposal that there is a presumption given to the decision of the parents that must be rebutted by the grandparents. You see what I mean? So that law is going to stay. That's not going to be overturned unless the United States Supreme Court grants certiorari to another case involving grandparents' rights, which is not likely, at least, on similar facts. But maybe if states we get situations like that Virginia case, and it's possible, but I wouldn't hold your breath on that. I think where the efforts need to be, where they are, is in testing the 34 states that do have a form of original jurisdiction for grandparents, and getting them, people say, well, let's not get them, let's just, because maybe some truth to this. Sometimes you file the action, it brings the parties in, they mediate, it gets resolved. So maybe you don't want to run it up the line. So in other words, somebody's going to sue under the grandparent statute, the parent's going to come in and appeal the decision, challenge the statute, you know, and then it's gonna go to this, in Florida, we got DCA, the District Court of Appeals, so it'll go to this interim court. At that time, the interim court can say, I find that that statute is unconstitutional. That doesn't mean that you still can't continue to bring your lawsuits. So that's an interim, you know, it hasn't been to the Florida Supreme Court yet. That's just one DCA. Probably can't bring it in that DCA. So the second DCA is our district. So unless it was us that made that decision, we can still bring our actions. And then it'll go up to the Florida Supreme Court and they'll make their decision. So that's, so some people think it's good to just have the statute on the books. That's why there's 34 states that have it. So you guys do have momentum though. But others say, let's get it challenged. Let's get these Supreme Courts to come in and start upholding them. Because that'll really get some teeth going. So that say, hey, here is the right of privacy, here's the compelling state interest, and here's the strict compliance with, you know, dealing with the problem without being overly broad. So, you know, these efforts are continuing. You are in a constantly moving laws, and I think, you know, quite just keep it up because we're getting somewhere. And, you know, maybe Florida will be the last, you know, one of the last, but they may do the best job too. I mean, there's a lot of effort went into their work, and I think you've got some devoted people. What I was kind of explaining to Susan and the board is that what we have to continue to do is we have to continue to be vocal with our congressmen, meaning our state congressmen more so than the federal. I mean, the federal doesn't hurt because they talk to one another, they're usually in the same building, but you want to get your state congressmen, they're going to know, hey, listen, I want to know, are you with us or are you without? And you know, and get your votes and get some motivation to get a statute on the books. Because I think once you get a statute on the books, you guys will have, somebody comes to me now, let's look at the practical reality. And I was thinking about that too. Somebody can tell me their story, come into my office and say, hey, I got this situation, this is horrible. And 9 out of 10 times I'm going to say, there's not much I can do. If they pass this law in Florida, I'm still going to say, you better be right, and we better win, because if we don't, we're going to have to pay their attorney's fees and ours. So it's not going to be 100% solution, but it's certainly going to be a way, you know, it's a step in the right direction. Yeah.
And I mentioned this to you privately, but you know, oftentimes you're dealing with personality disorders and narcissism and pathological lying. So I'd like to talk about pathological lying. And when I asked you if we went to court and they lied, which they're very good at, how do you justify going? You know what you're up against. You know you're about pathological liars. You're dealing with pathological liars, and you said the judge after a while sees a pattern.
Right.
Could you talk about that a little bit?
Yeah. I mean, you know, this is a constant battle that litigators have, and it's not just in the family law context. It can also be in the commercial law context, where you just get somebody that just says something that happened that didn't, or something didn't happen that did. And constantly, as lawyers, we pick our battles, and you really don't, you know, there's credibility. Somebody lies small, couple times, third time, fourth. At some point, they start losing credibility as a witness. Okay? So that can be a technique you use. But you don't necessarily want to go in there and attack emotionally and attack frontally, you're a liar. Because that's a big battle. You may fall just short of that. You may, you know, maybe they're not lying, maybe they're twisting the truth, and they get away with it. But a good litigator will know how to deal with that, because what you'll do is you'll put them on there, you'll let them start, you know, dig your own grave, let them talk. Liars, they forget their lies. Let them go. Judges are not dumb. And these, right now in Collier County, you've got two really good. Judge Cryer and Judge Grider are two excellent judges that understand. They have an innate ability to understand what's going on. And they know the predisposition and the emotion and the tendency to stretch and fabricate and distort. Personality disorders, now, you know, there's another issue. That's a little bit different. The problem that we've had with some of these alienation as general, as a disorder, alienation as a clinically defined, you know, syndrome. You've got a problem that the courts haven't quite gotten to the point where they're adopting that expert viewpoint. Because you're going to have somebody say, here it is, you know, Dr. Monk, he comes in and describes it articulately, great witness, he's probably going to blow any other competitive witness out of, you know, expert out of the box. But then you've got somebody else that's going to come in there and say, well, that doesn't really apply in this case, because in this case they're just trying to raise the children the way they want to. You know, and people have different views, and that's why we have a great country. And, you know, so you have a kind of a battle of spin, doctors on one side and the other, and you've got to rely on the judge. But I got to tell you, I think that, I'll say that more than half of your battle is getting jurisdiction, getting standing, and getting in front of a judge. Then let the games start. And then, you know, let's get it in front of, you know, you don't have to have that. So I think you get that, then we'll start worrying about the other stuff, which is educating the judges. I'll tell you, the judges they're pretty impressive in by and large, my experience.
Does the grandchildren and the grandparents have to be in the same state to make the law work?
Okay, yeah, that's a good question too. And again, that's jurisdiction. I kind of throw these terms out. I said standing jurisdiction and all this. Jurisdiction is the power of the court to issue a ruling or to hear a case. Okay, and jurisdiction is also defined by statute, which is promulgated consistent with the Constitution. So in the state of Florida, if you have been a resident for 6 months or more, you as a person have the court has a jurisdiction to hear your petition, assuming that you have a valid petition, which you don't. But if you get that, you'll have it. So you'd be able to come in and do that. Now, if the children and the parents are in another state, so let's say, you know, everybody's in Connecticut, you're down here in Florida, you go to Florida courts, what's going to happen then is we're going to have a battle of what we call forum non-conveniens, or a battle of what is really the more appropriate forum. That's not jurisdiction, that's more discretionary, but if you have more contacts in another state, so what would happen is if the children were adequately represented and you're adequately represented, you'll file your petition down here, they're going to probably get it moved to Connecticut because of the context. Now, it's kind of split up a little bit. So that's a complex question. But jurisdiction's a good start. But if you're the only one in Florida, you probably want to go there. On that score. Okay. Does anybody else have any more questions? Or do you want to try a test case and see? Anybody want to throw a fact case ahead and see what you might say about it? If okay. I thought about doing that. All right. So then let's go. So I just read you one statute, and I'll close by. I'd like to go to the next statute. Okay, which is the statute in Arizona, and this one says that a grandparent or great-grandparent. By the way, great-grandparents are a general rule, are usually covered in these statutes, and adoption usually terminates all of them. So I just want to kind of point that out. So you'll see some of that. It's not directly applicable, but you see that. Okay, they may petition the district court. There's your right, there's your standing. For reasonable, we didn't see that word before, reasonable visitation rights with respect to his or her grandchild or great-grandchild under the provisions of this section if the marital relationship of the parents has been severed by death, divorce, or legal separation. The parents were not married, that's out of wedlock, and have not substantially married. What's that? Okay, this is a real statute, I made this up. And the petitioner is a maternal grandparent or maternal grandparent to the child. The child's parents were not married when the grandchild was born and have not subsequently married. The petitioner is a paternal grandparent or paternal great-grandparent of the child. Very interesting. And then paternity has been established by a court of competent jurisdiction. So it's pretty broad. What do you think? Does anybody have an idea whether that would pass in Florida? Does anybody have any thoughts on that? Is that enough limitation there? Let's read on just to make sure. So, subparagraph D, a court in another state has ordered visitation to the petitioner. That's the situation with the Virginia court, okay? And I submit to you that Florida, it's interesting. I mean, basically that's kind of like reciprocity. Now, you can give reciprocity to another state, but you cannot get around constitutional protection by giving reciprocity to the state. The constitutional right of privacy will override that. So Florida could never pass a statute that says that if another state's given an order, we're going to acknowledge it no matter what it is. Florida's got to, I submit to you, has to look at the constitutionality of the statute that gave the right to the grandparents in the first place, because the right of privacy is written into the Constitution here. But anyways, and then there is a pre-existing, so then it says, okay, so those are all the provisions A through D in which you can petition. Then it says, the court shall not grant the petitioner reasonable rights over the objection of a fit parent unless the petitioner shows the visitation over the objection of a fit parent, unless the petitioner shows the following by clear and convincing evidence. There's another standard, by the way, clear and convincing evidence. Okay? It doesn't get much tougher than that in a non-criminal context. We have beyond a reasonable doubt in criminal, but we don't have anything higher in civil than clear and convincing. So it's pretty much, you got to win the balance, but you can't win the balance with vague evidence. You got to win it with clear and convincing evidence. It's a pretty high standard. So it says that by clear and convincing evidence, A, that there is a pre-existing relationship between the petitioner and the child, such as it would be in the best interest of the child to continue the relationship. And you see how best interest is okay there, because it's just determining, and it's limited to the relationship between the grandparent and the grandchild.
What if the grandchild has been programmed to think that, like the parents, it's not in their best interest?
We're out of fear.
Or out of fear,
Yeah, okay.
absolutely out of fear.
Well, it probably doesn't matter, because most likely, I mean, it depends on the state, but in Florida, generally speaking, it depends on the age of the child. Now, if the child is 13, 14, 15, the court might have some in-camera testimony, maybe, and possibly if they're 15 or 16, they might march them right into the courtroom and ask them. And then, then you got to get your expert in there. But if the child is below, say, 12, 13, and it's all guideposts, judge discretion. But then, generally speaking, the younger child, they're probably not even here with the child. Okay, there's a fit, the B. So that's the first thing. There is a pre-existing relationship. That shouldn't be too hard. The petitioner is a fit and proper person. Okay, that shouldn't be too hard either. Although, it can't be ignored. Number C, visitation by the petitioner with the child has been denied or unreasonably limited, right? That one's going to be pretty good. You're going to get that. So that's a three-part test that has to be showed by convincing evidence. Not too bad. And then it says, number 3, in determining the best interest of the child, the court shall consider all relevant factors, including, but not limited to the following. And then they list A through H, and they just have some fairly common things in here: mental, physical health, wishes and concerns, if age 12 years or older. There you go. The willingness of the petitioner to encourage a close relationship between the child, et cetera, et cetera. And then at the big catch-all at the end, any other factors in the best interest of the child. And look at G, the wishes of the parents. But it doesn't give them a presumption. Interesting, right? Probably Florida would get rid of that. But basically, it says, you know, we have to look to, and that's important, because if you don't look to that, the U.S. Supreme Court strikes it down. And then, 4, the provisions of this section shall not apply where there's been a termination of the rights of the biological parent to whom the petitioner is related. So you're still getting your rights through the child, through your son or daughter, as the case may be. So, that's a totally different, I submit to you, way of dealing with it and trying to get away from the U.S. Supreme Court limitation on the right of privacy. And it's by a state that doesn't have a specific right of privacy set forth in its constitution. So, and those are on the books. Now, the first statute that I read you, it has been repealed, declared unconstitutional. It's still on the books, but it's been declared unconstitutional. And the second one lives on. And I'm sure petitions are being filed. So we need to get with our state congressmen, write them letters, let them know you're there, and you might be surprised at where and when they will further what you tell them. And I suggest to you that keep mindful when you do this, and Sue and I talk about this a lot, they've got a lot on their plate. So make your letters short and concise. Try to pull, you know, the emotion is good if you're in person a lot of times. Like, it was very effective when you met with Kathleen Casadomo. And I'm sure she'll never forget that meeting. And I'm sure when it comes up in committees or whenever she's there, you know, it'll be there. But when you're writing a letter, I think you just want to make the point, and numbers are big.
If you want to write letters, you can copy and print anything off our website and just send that in.
Yeah,
The
just,
wording
you
is
know,
all
within
there.
Florida, I think the point should be not so much the specifics right now, because Florida is without any meaningful statute for grandparents. I think that's key. Everything's been stricken out of the old statute. We need a new one. Why? 1984, right? What was that, 30 years ago? It's time. Get on the stick here, you know? Most of that stuff's unconstitutional as of 2000. So let's get the statute. I think that's all you gotta really say. You say, please, I'm a grandparent. I need to be able to have mediation, go to court, I've been denied access to my grandchild, and I need a legal mechanism to get it back before my child grows up, something like that. You know, just get it out there. It doesn't have to be huge. Get them going. And I think, you know, one of the problems you have is the way it is set up in Florida. If you're a congressman in Florida, you're only allowed 3 bills through session, to sponsor 3 bills per session. If you're a senator, state senator, you're allowed unlimited. So we're probably going to be working with senators to get the bill sponsored. But it's got to make it through both houses. And that's where your letters to anyone are going to help. So I encourage you to continue it. It's a long battle. Susan's right. It's very political. But it's also very human. And, you know, and I'll close just by saying, you know, I asked my mom on my way here. I called her up, and she wanted to be here, by the way. She wasn't able to. But I said to her, I said, what do you think? I said, because, and we have, in her family, there's a situation of a grandparent that's really not a very nice person. It's really not a very healthy mentally person. And I knew this, so I asked my mom, I said, what do you think? I said, let's suppose something happened to the mother. And let's suppose that, the grandparent wanted to have access, like she has been, through the mother, visitation with the grandchild. Would you think she should have it? And I mean, she really does not like this person at all. And she sat back and she thought about it. She said, about not very long. She goes, yeah, I think she should be able to. And I said, well, but I submit to you that we've got some problems here. Privacy, and I'm kind of giving her a little bit of my talk. And she goes, well, that might be the legal side of it. She says, but morally, and that's the way she looked at it. Morally versus legally. Well, I'll tell you something. The day that the law departs from morality, that's the day we really got to work. And again, there's letters. Let's get the law there. Right now, you've got no access to the courts, not because of any moral failing. I think you've got it because we just haven't gotten around to it. It needs to be done. It's a lot of work, no doubt about it, but it needs to get done, and I believe it will be done. I think that 3 years from now, you know, maybe 2 years, we'll have some kind of staff.
You know, we have over 1,000 people on our mailing list across the country, and I could, hypothetically, I could ask everyone to
Yeah,
send it to.
I don't think that would be a bad idea. I think that would be a great idea. Let people know you're out there. Let people know you vote. I mean, they'll know that, right? I'm a resident of Florida, and I have a grandchild, and I'm being restricted.
Yeah, because every legislator that we've contacted by email that responded wanted to know what they could do. Any
Right.
legislator that we met with is in favor of it.
Yeah.
They want something.
Yeah, it's obvious. It just needs to be done. It's a priority list. The only reason it didn't get up for a vote in 2013.
It was a terrible
is
bill.
Well, it could have been better, but but that's not why. The reason it didn't get up for vote is because there were all these other priorities, the foreclosure law, the this law, that law, you know, all these high push buttons. Well, it's time. This should be a high push button because this is a large voting block, and it's the right thing, and it's about, and this is where really we made some headway with Rubio. We actually met with Senator Rubio's people, because not that he could really help us completely, but we thought maybe, you know, he knows everybody, push a few buttons here and there, and let me tell you, they were absolutely on point about the power of that voting block, and not even important, the demise of the family and the breakdown of the family. And if, you know, again, we're not asking, you know, here's a conservative Republican who the last thing he wants is more government intrusion into our lives. But yet, the fact is, government needs to support the family unit, because the family is what really makes the country great. And it's the breakdown of the family that could lead to a cultural and, you know, deterioration. Yeah. So
For the boomers, time is of the essence.
So I think you got momentum. I think you got to ride that wave and stay aboard, because if you don't, it's like a helicopter, right? You take it up there, it takes all the energy to get here, and then if you pull any of it down, it just falls, right? It's not, there's no coasting here. You've got to stay with it, and eventually it'll take root, and the right thing will be done. I believe that because I've read these decisions, and I see what these other states have done. There's a reason why 34 states have passed laws notwithstanding these constitutional challenges. They're saying, bring it on. And that's what Florida needs to do too. Okay, thank you very much for the opportunity.